Hello everyone, and welcome to the latest Blaser Mills legal update, hot topics in employment and commercial law. I'm Colin Smith, Head of Commercial, and I'm joined today by my colleagues Lloyd Gash and Barry French. And we're going to be talking to you about some recent developments in employment law, in particular government initiatives and possibly the biggest change to pension law for 100 years. We're also going to be telling you a little bit about directors' duties. So without further ado, I shall hand you over to Lloyd Gash.
Hello, I'm going to be shedding some light on some government announcements, in particular from Messrs George Osborne and Vince Cable, some changes to the ACAS, that's a Conciliation Services involvement in employment tribunal cases, and some changes that have recently been rolled out to the scope of age-related discrimination. Starting with the most topical, George Osborne in the October Tory party conference made an announcement whereby he envisages that employers can offer a new type of employment contract to new recruits whereby they are effectively trading off some long-established employment rights. Those rights will be unfair dismissal, redundancy, the right to request flexible working, and a shortened maternity notice period. And the thinking is that in exchange for giving up those rights, they will receive an award of shares in the company, valued between £2,000 and £50,000, and that on the disposal of those shares, which we would imagine most typically would be on the employer buying them back from the employee at the end of the period of employment, any increase in value on those shares will be free from capital gains tax. Very important to note that existing employees already under contracts of employment will be protected from, they won't be able to be forced to take up these contractual arrangements, and at the moment it is a raw proposal. The stated intention was for it to come into effect in April 2013. It strikes me as ambitious, but we wait to see. So I'm just going to give you some reaction that I found in the media to these proposals. Starting with the Institute of Directors, they're quoted as saying, "This scheme has the potential to reduce the employment law burden on companies and make employees better off at the same time." Now this will be music to George Osborne's ears, as it goes to the very essence of what he's trying to do with this proposal. Unsurprisingly, a contrasting voice, Trade Union Council's General Secretary Brendan Barber states, "We deplore any attack on maternity provision or protection for unfair dismissal, but these complex proposals do not look as if they will have very much impact, as few small businesses will want to tie themselves up in the tangle of red tape necessary to trigger those exemptions." I think that Mr Barber is very obviously having a pop here directly at Mr Osborne in citing that, in his view, this will lead to an increase in red tape as opposed to a decrease in red tape, which was one of the stated targets for the coalition government. Reduction of red tape, make life easier for employers to recruit. We wait and see what the long-term effects are. Vince Cable's reforms. The Secretary of State for the Department for Business Innovation and Skills, or BIS, has set out a number of reforms to the employment law arena. I'm going to pick up on three of those, starting with a proposed introduction of tribunal fees. At present, a claimant can bring a claim in the employment tribunal without having to dig into his or her own pocket to meet a fee. And this can lead to spurious claims being brought. So the onus on introducing a fee is to act as a deterrent for those spurious claims. By way of an indication of the likely level of those fees, for an unpaid wages claim in the tribunal, we're looking at an issue fee of £390. For an unfair dismissal or discrimination claim, an issue fee of £250, and a much more weighty hearing fee of £950. So these are not inconsiderable sums, and it remains to be seen when they're rolled out as to whether law firms will be desirous of sharing the risk and offering some sort of conditional or contingency fee arrangement with their clients to take the risk out of the claim. In an otherwise employer-friendly swathe of reforms, the introduction of a financial penalty against the employer losing at tribunal is the one measure that redresses that balance. The proposal is that a tribunal can order against a losing respondent a financial penalty where the tribunal finds that aggravating features apply. What this effectively does is introduce a third level of costs for an employer facing a tribunal claim. Firstly, there's the award that the tribunal makes in compensation or damages to the successful claimant. Secondly, there are, albeit a limited scope, for the recovery of some costs which are payable to the claimant in certain cases. The financial penalty goes further than even the second provision there, in that there will be a punitive award paid to the exchequer as opposed to the successful claimant of a minimum amount of £100 and a maximum of £5,000, and subject to a 50% reduction if paid within 21 days, much like a car parking fine. These aren't in place yet, and it remains to be seen what type of features will be classified as aggravating by the tribunal, and whether indeed there'll be an appetite to use this provision and make these kind of awards against employers. Compromise agreements are being renamed to settlement agreements. Why am I talking to you about this today? Well, aside from the name change, there is actually a material difference being brought in to the regime of compromise agreements, and that is that settlement offers made as between an employer and an employee will be inadmissible in claims for unfair dismissal. As things stand, a claimant can disclose the fact that such conversations existed before the claim was issued in the tribunal, and that could act against or have a prejudicial effect against an employer at trial. So the intention is that introducing this measure of inadmissibility of those kind of conversations will free up employers to be able to feel more comfortable, more safe about approaching employees at an early stage where the employment contract isn't working out, to have a discussion to facilitate a settlement. The BIS consultation closed on the 23rd of November 2012, and the matters under consultation, the results of which are not yet out, are whether there should be an ACAS code of practice to guide employers through the when and the wheres of these kind of discussions. Also, whether there should be an optional model settlement agreement with guidance notes available on probably the BIS departmental website, and less likely whether there should be a guideline tariff to set severance amounts so that employers can effectively look at a chart, pick a figure, apply it to the facts and pay out a certain sum of money. At present, ACAS are duty-bound to become involved in all employment tribunal cases once they are issued, and the parties involved in the disputes can, if they choose to, bring that forward. There's a proposal to make that a mandatory step, so that before lodging a claim, the claimant must report that on a prescribed form to ACAS, at which point a conciliation officer will get involved to try and promote a settlement between the parties. If there's no agreement as a consequence of the ACAS officer becoming involved, a certificate is issued and then the claim can proceed. The limitation period, which is strict, in which claims must be brought, will be extended when a report to the ACAS officer is made, effectively stopping the limitation clock and freezing it for a period of 1 month. Age-related discrimination. As of the 1st of October, age has become a protected characteristic in the provision not only of contracts of employment or employment services, but any goods or services under the Equality Act 2010. As I've said, it's already a protected characteristic in relation to employment. So you cannot choose to employ somebody over someone else on the basis of their age. But this has been rolled out and extends to customers and users of services in terms of who benefits from the scope of this legislation. Is this relevant to your business? Well, in short, yes. It relates to the provision of goods and services, and we are all in the business of providing goods and/or services to our customers. Employers are liable for the actions of their staff vicariously, so we'll need policies in place to deal with the risk of any process which is potentially discriminatory against customers, client bases, on the basis of their age. Less favourable treatment will be given a wide definition to include treating people with a lesser degree of courtesy, lesser standard of service, or subjecting a person to any kind of detriment based on their age. There are a number of exceptions. Things done in relation to the provision of a financial services, for example. So an insurance provider calculating a premium and using age as a determinant factor falls neatly into that exception. Concessions and preferential treatments by traders. We're talking here about your discounted haircut for your pensioner or your concession on a cinema ticket for your under-21s. On the face of it, discriminatory. Couldn't be clearer in terms of preferring one set of people over another on the basis of their age, but caught by an exception and therefore will not give rise to the risk of a claim. Unsurprisingly, selling goods or services that are themselves subject to legal age limits, tobacco or alcohol to under 18s, fits within an exception. Running alongside those stated exceptions is the test of objective justification. This test is what you are doing a proportionate means of achieving a legitimate aim? And there's government guidance on this, and it refers to showing sufficient reason in layman's terms. So, for example, if you own a villa and you don't want to let it out to a group of young lads on a stag do, the preservation of the property itself may be the reason for making that decision. I would contend could be argued as being a proportionate measure. Limiting the number of school children in a newsagent at any one time, potentially, if we apply the test of age-related discrimination, puts him at risk. But it is arguably proportionate to do so because they're not being banned from the shop altogether. I'll leave you with the Government Equalities Office guidance on this point. You cannot treat someone differently on grounds of age if the practice is not covered by an exception or cannot be objectively justified, as I've just referred to. You can never harass someone for reasons related to their age or victimise them for making a complaint. It's really the second part of this guidance which should cause you concern if there's any chance that your employees are engaged in that kind of conduct.